Hello, everyone, and welcome to Immigration and Jobs Talk Show. I am Nipasa Pradhan, and I'm going to be with you for the next hour. We're going to have a very awesome discussion. I hope you have been sticking with us on our channel. So, before we move ahead with today's second webinar, I'm going to just tell you that, by watching our video, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. And once again, folks out there, a very warm welcome to you. Thank you so much for joining us. And it's going to be another insightful episode of Immigration and Jobs Talk Show. So, I'm really thrilled to have all of you join us today, whether you're tuning in from YouTube, LinkedIn, Facebook, or even Twitter. Thank you so much. We're so delighted to have all of you. And please feel free, to engage in the discussion, by commenting whatever questions you have about the topic and directly to our guest as well. So, yes, I mean, today's guest is none other than Attorney Chand Parvathaneni from the law firm of Sim Parvathaneni and Brown PLLC. So he has been specializing in immigration law and has been practicing and is based out of Texas. So please help me welcome him once again. How are you doing, Chand, today?
Hello, Nipasa, and hello, everybody watching this show today. Thank you so much for inviting me, and then hopefully we will have a very informative discussion today.
I'm sure. And thank you so much. So, before we move ahead, would you like to tell us about yourself a little bit and even your law firm so that folks out there can, be interested to contact you directly as well?
Sure. So our law firm is based in Dallas, and I've been practicing as a lawyer in Dallas area for over a decade now. Started my practice in 2011, and over more than a decade of my practicing immigration law here in Dallas area. And I've been living in Dallas area since 2000, almost 23 plus years in Dallas area. And during the course of my career, I uh, I try to focus myself on the employment-based side of the immigration. The employment-based side of the immigration is basically the H1Bs, the L1s, the EB1, EB2, EB3, EB4, EB5, these kind of immigrant petitions. So so these are the kind of cases that I typically deal with. And during the course of our experience, due to the kind of volume of cases that I work on, I typically work on over 3,000 cases a year in the recent years. So more than 3,000 H1B cases a year is what I work on. And based on the number of cases, we see a lot of data. See the adjudication patterns, the hiring patterns, the kind of the salary patterns. And not only that, we also see the kind of issues that pop up. We work with a lot of these filings, and most of the times the issues are always like recurring. And especially for the H1B, there is not a whole lot that USCIS can ask. You can probably characterize um, most of the issues as 10 important buckets. So typically, it's always these questions about either the beneficiary qualifications, either the company, either the specialized position. So it's a very limited area. So even though the field looks pretty complex, the kind of issues that pop up between company to company, case to case, it's always you can kind of predict what kind of questions could be asked based on a case. And I think that is what I think we want to share. We want to share the kind of issues that we see, and we want to see the kind of issues that you are seeing, so we can kind of tell you what's going on and give you more information. So hopefully we can get started, and then let's discuss more about the current trends, the kind of site visits that are happening, and then any kind of changes that people can anticipate in the H1B program going into the future.
That's right. That's right. And that is what today's topic is, friends. Today, we will be shedding light on a crucial topic, which is are H1B site visits on the rise? And we are going to unveil the truth behind the recent immigration changes. And definitely, Chand is going to shed a lot of light on this. So, without further ado, let's dive right into the topic. And my first question to you is, you know, uh, mm, how First question to you is what are site visits and what happens when the site visit happens? Chand.
So the site visits typically are a visit by a USCIS officer, and these typically happen more than likely for the H1B cases. So they do the site visits for a lot of other cases too, but in general, when we talk about employment-based immigration, we talk about site visits. This is a visit typically by a USCIS officer, and this is where the USCIS officer will actually come to the office, and sometimes even the home of the employee. So this is what is a site visit, and this entire site visit program, it started off in 2009, and it started off as a part of a program called ASVVP, Administrative Site Visit and Verification Program, and that program is what started this. And these site visits happen as a part of an organization called FDNS. It's Fraud Detection and National Security Directorate. So it is a part of FDNS Directorate, and as a part of this FDNS visit, these officers visit the location. And typically it is the location of the company, location of the work, sometimes even the home of the employee. And the goal of these officers, it is not to arrest somebody, not to do any of those kinds of stuff. These officers are not law enforcement agencies, law enforcement officers. So a law enforcement officer is like somebody like a police officer. They come, they could arrest somebody if they have a warrant, and so on. So these officers, the site visit officers, the FDNS officers, these are officers who are trying to ensure compliance with the H1B petition. So all they're trying to do is come to the site and observe what's going on, maybe take some photographs, maybe write some answers, and write a report and send it back to USCIS. So these are not officers who can arrest somebody. So a lot of people get very worried because they see a government officer and they get worried. Hey, I have a government officer sitting in front of my home or in front of my office. Did I do anything wrong? It's not that. A site visit is basically, it's a part of the entire H1B program. These officers, most of the time, they just walk in randomly, and a lot of times it is not even targeted. Any company can get selected for an audit, and these officers just come in, and their goal is the employee and the employer complying with the H1B program. So they're just checking the compliance. They're more interested in the compliance. And what that means is the employee getting paid like he should? Is the employee working like he should? Is the employer paying the employee like they should? Is the LCA appropriate? And did the employer provide a proper workspace? And so on. And nowadays, what we're seeing is a lot of people in the last 3-4 years, ever since COVID, people have been working at home. So technically, the home is the work site. So anytime we see the home as a work site, the officer can definitely go to the house. And we have seen officers go to the apartment, go to the house, and say, "Hey, can we come in?" And it is always a voluntary participation. So a site visit is not something where somebody has to participate. At least as of today, this whole administrative site visit and verification program, the site visits are still voluntary. So somebody is in their own right to say that, hey, I will not let you come into my house. You cannot come, and I refuse to participate. Somebody can always say that. That being said, what we recommend is try to cooperate with them as much as possible. Try to give them the information, as long as it is pertinent to the H1B filing. Things like your job duties, things like what do you do, things like your pay statements. I think people should try to cooperate. It is definitely a voluntary program. So if somebody says, I don't want to participate, it is not that USCIS will go and revoke their H1B the very next day. That it does not happen. It is still a voluntary program, but the reason you want to comply is because it is good for the company and the employee to at least get through this whole site visit and show compliance, because at the end of the day, all they're interested is, are you getting paid, are you working like you should? And that is their main goal. And if you're able to prove that, it is always good. So try to participate as much as possible. And in general, sometimes what officers do is sometimes they try to ask information that is not relevant. Maybe they're trying to fish for some additional information. Maybe that is a time when you definitely need to involve an attorney or see whether you want to participate or not. But if it is anything very core and specific to the H1B filing, and things like validate your job position, your salary, and so on, definitely participate. And it is one way of proving that you're complying with everything like you should. So, in essence, a compliance review is not anything serious. It is not anytime you have a USCIS officer in front of your home or in front of your office, there is nothing to worry. It can happen to anybody. Most of the time it's a random site visit, and there is nothing wrong with your company or with you, and it is just a part of their H1B process. So just try to reach out to your HR if you're the employee, and if you're the HR, uh, try to reach out to your attorney if you see something is not going right. Okay. So
Mhm.
overall, this is something what people can expect going into the future, and it's just a part of this entire H1B program.
Right, right. So whenever, I mean, they can make any surprise visits, or is it like very planned, and they do not visit every site, of course, right? So anything you want to say
Yeah,
on that?
most of the time it is. Yeah, most of the time it is unannounced. They don't typically give any notice. They just walk into the
Okay.
work site and they just try to knock on the door. If it's a home or if it's an office, they just try to go to the receptionist and say, "Hey, we are here to
Mhm.
meet so and so person," and it is unannounced. And then again,
Mhm.
there is nothing to be worried because sometimes the officer comes to the office and somebody is not at the office. There is nothing to worry. The officer typically they will try to contact them on the phone or on the email, and
Mhm.
try to again make up some time down the line. So there's nothing to worry if the officer comes in and you're not in the office. There is no problem. You can always contact the officer back, or the officer will contact you back, and then you can provide them the information that you require. But in general, it is almost always unannounced. They don't give you advance notice because the whole reason they're even doing this visit is to see if somebody is complying with the H1B program. And that is one of the reasons why they do unannounced site visits. And most
Mhm.
of the time, it is like nothing to worry about. And very rarely we see issues happen with the site visit. Issues do happen, but again, it is
Okay.
very rare. And normally, what happens is the worst that could happen is if they come, they do a site visit, and they find that somebody is not complying with the H1B regulations. They're not working, they're not
Mhm.
getting paid, and so on. And
Mhm.
what would happen at that point of time is they will write a report. They will send it back to USCIS because all they will do is they will send the report back to USCIS. And back at USCIS, when they see the report, they're not satisfied. They will issue a notice to the company, either a notice of intent to deny or a notice of intent to revoke, and say,
Mhm.
look, our officer has done this site visit. They found these findings, and they don't look like you are in H1B compliance. And they will say, reply back to us. And sometimes
Mhm.
maybe the officer made a mistake. So you can always reply back with your evidence and try to fix it. So it is not end of the day. USCIS officer comes to your office, maybe does a site visit, maybe
Mhm.
they write a report. But even if the report is bad, USCIS will always give you another chance by sending you a written notice, and then they will ask you to respond back. So it is not end of the day. People will always get a chance to respond back to USCIS if there is a problem. In general, as long as somebody is getting paid and somebody is working like they're supposed to work from the work site, in general, there is always like no issue, 99% of the time.
Okay, okay. Thank you so much for that detailed explanation, Chanda, and for just giving us an insight on what we will actually be talking about today, friends. So, if you have questions, definitely drop them, and I can actually see some of the questions already. So, we will take them up. I'll just say hi to everybody who's joined us. Thank you so much, and for your comments as well. Yugandhu, Dharuv, Riha, then we have Neha, Varnika. We will take your questions. Just stay with us, okay? So yes, Chand, let's move on to the next question that I got for you, and that is, with a background in commerce and a successful H1B lottery outcome, what additional considerations should be noted aside from having 10 years of IT experience?
So, based on what I see in this question, looks like somebody has a background in commerce, not really a computer science background, a commerce background, but they do have 10 years of IT experience. So, I'm guessing this person wants to work in the IT profession because of their IT experience. However, on the USCIS side, when the employer actually files the H1B petition, the education is a very important part of the adjudication. And we always require a 4 year degree. So, for example, commerce. In India, BCom is a 3 year degree. So, if you have a 3 year degree, the rule is since you do not have a 4 year degree, you at least need to do an evaluation, and the evaluation is for your experience plus your 3 year education. You have to get the evaluation done by a US professor. So if the US professor takes a look at your experience documents, takes a look at your 3 year degree, And if they are able to do an evaluation and they are able to provide an equivalency, then you should not have a problem. So normally what we do is we take the experience letters, we take the degree, the 3-year degree, we ask for an expert opinion. And for most of the cases, if somebody has 10 years of experience with a 3-year degree, the professors typically, they should be able to provide an equivalency. So they call it a work experience, a combined work experience plus education equivalency. So when they combine both of these together, they will be able to state that you do have a equivalent, not a real degree, but an equivalent degree of a bachelor's in computer information systems, for example. And once the professor agrees and gives us a report, what we do is we use that evaluation, send it to USCIS and say, look, this person, because of his experience with his 3-year degree, now they have a 4-year equivalent degree. And doing so, we will be able to argue. And the current USCIS regulations let you use experience and work education combined evaluation from a US professor to qualify you for a H1B. So typically, the summary is go to a professor, get an evaluation done, use that evaluation for your H1B filing.
Great. Thank you so much for that. And also, what about this recent Dropbox? Is the Dropbox option available for H1B visa holders holding a B1 visa from India?
Luckily, the Dropbox feature, it got extended even this year, so people are still able to take advantage of Dropbox. And the only rule is if you have a US visa in the past. So, for example,
Mhm.
B1, H1, F1. So, if you have a US visa in the past, and then you're trying to go for your H1B stamping, currently the current rules are letting people get Dropbox appointment, and Dropbox appointment is a great feature because it eliminates the interview. And for most of the folks, they do a Dropbox, they're able to get a visa stamping. Very rarely, even if you have a visa in the past, sometimes they do call you for an interview, but majority of the cases who have a visa, they are getting this interview waiver, so they don't have to do this interview anymore. They just have to do a Dropbox, drop their documents in the Dropbox, and get the visa. So it has definitely streamlined things in the India side, and people are getting their H1B visas a lot quicker because of this Dropbox. Previously, when we had the interviews for everybody, it was a challenge to get an interview date, and it was very slow. So the main advantage of Dropbox is it is going to make things smoother and quicker for those people who have a US visa sometime in the past.
Okay, okay. Thank you so much for taking that up. And let's take up one from the audience. I think let's take up Yugan Dharuv, who has a question for you. He says, hi, by the way. So the question is, I having 3 years of career gap between education and work experience. Will will the visa get approved? 3 years of
Sure.
career gap
So
between education and work experience. Okay.
yeah. So it is common. A lot of people do have career gaps. For example, I see a lot of people, they take a gap, they have children, and they don't work for a couple of years, and then they go back into the industry. So a lot of people do take career gaps. There is nothing wrong. So USCIS requirement is somebody needs to have an equivalent bachelor's degree in that right field. So as long as you have that equivalent bachelor's degree, if you take a career gap, that is not a problem, assuming you have the right degree in the right field. So it is more about educational equivalency and not about having a continuous career. So if you do have a gap, that by itself should not cause you any problem. If you have the right degree, experience is not even required. But say you don't have the right degree, then you require experience. But assuming you have enough experience, enough education, the gap itself is not a problem at all. Okay, so no, normally we don't even see that question asked, at least at the time of filing for USCIS. Nobody's going to raise that issue and say, why did you have a gap in your career? It is not a problem. That being said, at the consulate, on the consulate side, if they see a gap, they might say, hey, what happened? Why did you take a break in your career? And it is more to know about your profile rather than use it as an eliminating factor. It is not an eliminating factor. It is more to see what
Mhm.
exactly happened. And different people have different reasons. Sometimes people just want to study. So what happens is people all of a sudden they take a career gap, they go back to school, they get education. Sometimes people get married, they take a break, they have kids, and then go back to work. So it could be anything. So as long as it's a valid reason, uh, the gap itself will never cause you a problem.
All right. So, Yugan Dharuv, there is nothing to worry about. I think you can definitely go ahead, and there's never going to be a problem. So, all the best for your interview or for your visa as well. Okay, then, and moving on to the next question that I have for you, Chand. I also wanted to know. Suppose, can individuals travel to India after H1B approval, but before its activation, such as traveling in November with a December 1st start date, and, provided stamping is completed beforehand, that is.
Sure. So if you're talking about somebody got a H1B approval with a future date, because most of the folks who are getting approvals now for the cap, their start date will
Hmm.
be October, for example. And this year,
Okay.
USCIS is letting us put a future date. So you can even put a December start date, get an approval with a December start date.
Okay.
So because for the cap, you put a future date. And
Hmm.
if somebody is wanting to travel after they get their approval, it's completely valid.
Hmm.
They can travel to India before their H1B kickstarts. They can go to India, and if they want to go get stamping, they can get stamping. And if they have a valid OPT, for example, sometimes they might
Hmm.
even be able to come back on their F1 visa, depending on the situation. But say they don't have stamping, they have to go for stamping, for H1B stamping. They will get H1B
Hmm.
stamping, and then once they get
Okay.
their H1B stamping, they can come back. The only rule that people have to keep in mind is that if you have a H1B start date, for example, December 1st, you get a visa,
Hmm.
you can only come 10 days before the H1B starts. So if your start date is December 1st, you can come to US only after November 30th. If your start date is October 1st, you can come to US only after September 30th. So if you're coming back after getting your visa, make sure you come only within the last 10 days or after the date starts. You cannot come too early before your H1B starts. Uh,
Hmm.
Other than that, travel by itself should not cause any problem.
Okay, that is great. Thank you, Chan, for taking that up as well. And my next question to you is: what if an H1B petition was filed with an expiring passport? What implications might arise when seeking visa stamping with a new passport? Is it going to be a problem?
I know for a lot of folks, sometimes passports expire. Sometimes they even lose their passport. They won't even have their original passport. So it's okay
Okay.
that the passport that the H1B was filed is not active at the time of visa. It's completely valid. The only thing is,
Hmm.
in those cases, when you fill up your DS-160, make sure you put your most recent active passport. Give the most recent active passport to the consulate for stamping. It should not be a problem because your most recent passport will have reference to the prior passport. That number is there, and the
Hmm.
consulate will be able to tag it. So, in general, if you have an expired passport or a lost passport, no problem. Just ensure that you put the latest and valid passport in your DS-160 and then move along for your interview.
Okay, great. Thank you so much, Chand. And that gives me to the next question. So, what if, will a 3-year bachelor's degree from India pose any obstacles when applying for H1B, particularly with a background in STEM and as and an MS from the USA? So, will what is, yeah.
So, normally, if you have a 3-year degree, you need a lot of experience to make it up to four
Okay.
years equivalent degree. But in
Hmm.
this particular question, looks like somebody has a 3-year degree, but they also have a US master's after their 3-year degree. So if somebody has
Yes.
a US master's, then it doesn't matter at all because that US master's is equivalent or more than the bachelor's degree in US. So if somebody has a US master's degree, even if they have a 3-year degree, it will not make any difference at all. They should qualify based on just their master's degree. And when
Mhm.
somebody has a master's degree, does not matter. They did not have a 4-year degree back in India, so they should be fine.
Okay. Okay, great, great. So what if we have this 3 years bachelor's degree, and then we also have these internship programs, which are maybe 3 months or 6 months. Do they even qualify, or it has to be longer? How does this experience count, like to make it equivalent to 4 years?
So, in general, 3 years of experience is equal to 1 year of education as per US equivalency standards. So, if somebody has only 3 years of education, we require 4 years of education. So, they're lacking 1 year of experience. But
Right.
in the current USCIS standards, 1 year of education is equal to 3 years of work experience. So what
Okay.
happens is, if somebody has 3 years or more of that experience, we have to get those experience letters, give it to a professor, and the professor will be able to see, and they will be able to provide an opinion if
Hmm.
that experience is relevant in the relevant field. So they will use that 3 years of experience in that relevant field to equate that to 1 year of education, and then they will add it up to their education, and doing so they will
Hmm.
give them an equivalency. So if somebody does
Okay.
not even have a 3 year degree, they will require 12 years of work experience. So if somebody has 12 years of work experience, no bachelor's at all, they will also be able to qualify for the H1B, because 3 years of experience is equal to 1 year of education. So
Right.
if somebody has 12 years of experience, even without a bachelor's degree, they can qualify. And if somebody has
Oh,
3 years of education, like a BSc, BCom, BA, then that 1 year, and that 1 year of education can be compensated by having 3 years of work experience. But end of the day,
okay.
this experience has to be evaluated by a US professor, and the professor should write an evaluation, and then it can be used.
All right. All right. Thank you. That was pretty clear. And that gives me the next question, which is already on the screen. Does having 3 years and 8 months of IT experience, predominantly on a single project, meet the criteria for H1B petition approval, or could this raise concerns?
So again, if somebody has a, say, a bachelor's degree in the right field, so somebody has a BTech in computer science from India, for example, you don't even need experience. Experience is not mandatory for H1B program. It is the
Okay.
education or education equivalency. So if somebody has the right education, for example, a bachelor's degree in computer science, a 4 year degree, we
Mm.
don't require experience at all. So if somebody is saying that they have 3 years and 8 months of experience, if they have the right degree, this is not even required. So they have more than what is required. So they are good. So it is only when you lack education, then you rely on an experience. So overall, 3 years of experience with a bachelor's degree, your case is definitely strong, and you should not have any issues at all.
Awesome. Awesome. Thank you so much. I mean, we discussed quite a few examples, right, of 3 years degree and having a few experiences. So hopefully, folks out there, it's pretty much clear. And I think we should take up one more question from the audience. And let's go on to Riha. Riha is asking, what legal precedents or regulatory frameworks govern the scope and conduct of H1B site visits? And how do recent judicial rulings or legislative changes shape the enforcement landscape surrounding H1B visa compliance?
Sure. So currently, the site visits, they're a part of administrative site visit and verification program, ASVVP. They operate under FDNS, the Fraud Detection and National Security Directorate. So currently,
Mhm.
the, this body governs the current site visits. And in terms of the current legal framework, the site visits are voluntary. And what that means is, if the USS officer goes, they cannot insist on getting an answer. If the employer says that, hey, we do not want to participate, we want to stop it, the officer has to stop it. Right now, it is completely a voluntary participation. So nobody is saying it is mandatory. And what that means is, if somebody refuses to participate in a site visit, tomorrow USCIS cannot use that reason by itself and revoke the H1 all of a sudden. They cannot do that. So it is currently it is still a voluntary process. However, in terms of the changes that are coming, recent changes, what has happened last year is, in October 2023. Uh, so the DHS, they published a draft, and this draft, you can Google it, modernizing H1B program, in October 2023. So a draft was published in Federal Registrar, and as a part of the changes that they want to happen in the future. One of the things they are suggesting is that the site visits will be mandatory, and they're kind of trying to kind of make it more tight, and saying what kind of authority USCIS has, and what if somebody does not participate, and so on. So so at least we are going towards a path where this current voluntary participation could change, and it could become mandatory. And if somebody fails a site visit, more than likely the H1Bs can be revoked. But right now, this is just this It's just a draft. It's a proposal. It is published. It was published in October. There was a 2 month commenting period. The commenting period ended in December. So it's out there. The draft is not finalized. But at some point, we think that they will publish the finalized changes in the Federal Registrar. It has not come yet. And the final output could be entirely be different. But at least what we know is that the process has started to change the way the current site visits are done, and USCIS is trying to make it from voluntary participation to kind of mandatory participation, and they are progressing. So they have to follow something called Administrative Procedure Act to get these new rules into place, and that has started. So last October, it was published in the Federal Registrar, and as required by the Administrative Procedures Act (APA), people are given a chance to comment. The commenting period has ended, and now at some point they will finalize their rules. So to summarize, right now, uh, it is not mandatory. Down the line, things could change based on what we have seen in the draft proposal published in the Federal Registrar last year.
Okay. Thank you so much, Chand. And I hope that was pretty much clear, Riha. If you have more questions, we're still here for some time. You can keep commenting in here, wherever you have joined us from. So, Riha was on YouTube. Thank you so much for joining us. And I have one more question and then we'll go for a short break, friends. But you keep commenting, all right? We'll be very happy to take them up. So, my next question to you, Chand, is if someone faced location related issues with their H1B and subsequently transferred employers, could this history affect an impending extension?
Sure. When somebody's on H1B program, everybody has to get a copy of their LCA. So the employers don't have a choice. The employers have to give a copy of the LCA to the employee. This is a mandatory requirement. So every employee on H1B program, they should keep a copy of their LCA. It is very important. They should open up the LCA and look at their work location. They should look at their salary. They have to get paid that salary, a minimum of that salary. They have to ensure they only work from that metropolitan city that is listed on their LCA. Also, they have to work only in that occupation that is listed on the LCA. This is very important. So when someone says they faced a location related issue, what that typically could mean is they did not work like they're supposed to, as required by their LCA. Their LCA has a particular location. More than likely, they did not work and they ran into some issue. So what that means is, in general, if USCIS notices, they will issue a notice, whether when somebody files an amendment or whether somebody files an extension. If USCIS notices that there is a location issue, what they do is they will try to deny the H1B or at least the maintenance of status part of the H1B. So that kind of a thing is possible. And sometimes when people see that, they try to change employers. That also happens. So when somebody tries to change their employer and USCIS notices that they ran into a problem in the past with a location, somebody did not work like they're supposed to at that particular location, USCIS could cause a problem. And legally, the way to solve that problem is ask for H1B approval without I-94. So people, what they have to do is they get an approval, they have to go out of the country, they have to re-enter the country, get re-inspected back into the country, get a new I-94 to solve the issue. So what that means is if there is a location related issue, when you do a transfer, again, it might pop up over there, but there is a way to fix it. And the way to fix it legally is get the approval without the I-94, go out of the country, re-enter, and that would fix the location related status issue if you have any of those kind of issues in the prior filings.
Thank you. Thank you so much, Chan. That was pretty enlightening. And, I think we have come to the end of the first half of our session today, our webinar. And friends out there, I'm sure, that this is not just a one-way thing. So please drop your questions in the comments below. We will be very happy to take them up. And Chand is also here. In fact, you can even directly contact Chand. Call him in the number 817-523-8247 or call, or even email him at law@spblawfirm.com. And don't forget to also visit his website, spblawfirm.com. And don't go anywhere, folks. We will be discussing further on this topic. Are H1B site visits, in a high rise? And we are definitely unveiling a lot of truth behind the recent changes as well on immigration. So stay with us. This is Nipasa Pradhan on Immigration and Jobs Talk Show with none other than Attorney Chand Parvathaneni. Stay with us. We're going for a short break. Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335 6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com. Welcome back, friends, to Immigration and Jobs Talk Show. This is Nipasa Pradhan, and today we are discussing about our H1B site visits on the rise, and we are discussing and unveiling the truth behind this recent immigration changes with none other than Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. And it's been so far so good, right, Chand? Thank you so much for taking up our questions and also questions from the audience out there.
Sure, it is going pretty good so far, and you've been asking very informative questions, and I also see a couple of very informative questions in the chat window, and we'll get to them as we go along in the next couple of minutes.
Absolutely. So I think, Chand, my next question to you would be, suppose an H1B expired in August 2020 and they have obtained a new approval petition under July 2023. Would he qualify for the Dropbox when planning a trip to India in January 2021? And does a change of employer necessitate as an in-person interview?
So, if the employee had an H1B visa in the past or any kind of a US visa in the past, even though the prior visa expired or the prior H1B expired and they have a new H1B, they should still qualify for the interview waiver, which is basically the Dropbox. And even if they change their employer, it should not impact at all. So change of employer does not impact it at all. So the rule that they have been using is if somebody has a US visa in the past, um, and currently they're going for a H1B interview or a
Mhm.
H1B visa, they typically will get the Dropbox unless like their visa was revoked or cancelled in the past for some reason. In general, if
Mhm.
they had any kind of a US visa in the past and they're going for H1B stamping, they should get the Dropbox. And it doesn't matter that they changed employers or they had a break in H1B. So all those things should not matter.
Okay. Okay, thank you so much. And tell us if it is feasible, to switch from H1B to H4 EAD and later return to H1B again, utilizing the remaining 6 years of H1B eligibility. Is it possible?
Yes, anybody can change from H1B to any other legal valid status in US. So if somebody wants to change
Mhm.
from H1B to H4 EAD, it is just one of the change of statuses available. So one can
Mhm.
definitely go back to F1, H4, B1, B2. So all of these are valid statuses that one can change to from H1. And if somebody
Mhm.
decides to go to H4 status, it is completely permissible. And the good thing is somebody can stay on H1B for 6 years, and this is without an
Mhm.
I-140. And if you convert to a different status, the minute you convert to a different status, you don't count the period you're in US on H1B. So tomorrow down the line, if you decide to go back to H1B, you can recapture all the time, and all the time is not counted as on H1B. So technically, yes, you can go to a different status, and down the line, whenever you want to, you can always switch back to H1B. So there is a process to do that, but yes, it can be done. And a lot of people sometimes even do it because they don't want to completely finish their 6 years of time. sometimes.
Mhm.
And they do go to H4 EAD, and sometimes down the line they decide to come back to H1B if they see a reason. And if they don't see a reason, they try to kind of end up staying in H4. So it is legally it is permissible.
Okay. All right. That is good news then. I think, Chand, we should take up a few questions from the audience right now, right? I can see
Mhm.
some more
Yes.
popping up. So let's take out Varnika on YouTube asking, how do companies typically prepare for H1B site visits, and what are the common compliance issues found?
So, so I always see some companies are very organized with site visits. Some companies are very, very reckless, and they kind of keep running when they have a site visit. In general,
Okay.
most of the companies, what they do is they have their files in order. When I say the files in order, they have their LCAs, their payroll, everything where they can easily get to. So,
Mm-hmm.
and they always will assign somebody. So if there's a site visit, a company has a site visit, they always know who's responsible to answer it. So what that means is, if you have a HR, you have a couple of managers, then you have the president of the company, and so on involved. For example, they always assign somebody. So the minute they have a site visit, they have like a proper process. So they always come up with a process who's going to answer the the officer. So and then the payroll, because payroll is super important. So
Mm-hmm.
where exactly is the payroll? How do you get access to it? So the person, whoever is answering the officer, they should have access to the payroll, the file, the entire file of the employee. And so what that means is everybody should lay out the process. Who is responsible? Where are the files of the employee? Whether it is LCA, whether it is I-9, whether it is the payroll, and so on. So where do you have all that stuff? So that is what people typically have a process for. Where to get these documents? And assuming somebody who's responsible for the site visit has access to all of these things, site visits in general are very easy. They're not really tough. Very, very simple questions get asked. And when we talk about what are the common compliance issues that are found, if the employee is working in that same occupation, in the right location, getting paid like they should, in general, there are no issues at all. In general, the issues we find are when people are not working at that location because the project was over and somebody forgot to file an amendment, or their salary, their payroll is not getting paid like it should. It is not meeting the H1B compliance. It's not meeting the LCA. So these are the kind of issues that we normally see, because some people they do a location, they have a project change and they forget. Sometimes they forget, sometimes maybe they missed it out. But again, it's non-compliance. So whenever there's an amendment, it is super important that it gets filed before the employee moves. So that is one of the most common things that I typically see. People forgot to file an amendment. And pay statements, most of the time people, the companies are careful, but sometimes for whatever reason the payroll is not matching, because somebody, what happened is they did an amendment, the salary was increased, but they probably did not update their payroll, so the payroll is still getting paid the old salary, for example. So normal
Yes.
issues I see are payroll issues, or somebody not working at the right location. These are the common issues that I see, with the issues that I see. That being said,
Mhm.
majority of the cases typically go through successfully. So what I advise everybody is, always every month make sure you know where your employee is working from. Make sure your employee is not relocated, because nowadays, because everybody says remote, a lot of
Mhm.
employees don't know, and they feel that they can work anywhere in the United States. That is not the case. They still have to stick to the metropolitan area that is listed on their LCA. So even if the client
Mhm.
says yes, you can work remote, even if the employer says yes, you can work remote, the employee cannot work from anywhere they want. They are required to
Okay.
stay in the metropolitan city that their LCA defines. So that is very
Mhm.
important. And it is a confusion with that word remote. People think that they can work anywhere. No, it
Right.
has to be listed on your LCA. So that is why I tell everybody, all the employees, keep a copy of your LCA, look at what the LCA says. Do not move out of
Mhm.
that city or that metro area. If you have to move out of that metro area, make sure your employer knows, make sure they file an amendment before you actually move and work somewhere else. So
Mhm.
just comply with the LCA, and in general, don't anticipate any issues.
Okay. Thank you so much. I hope that was clear for you, Varnika. Thank you so much for joining us. And if you have any further questions, keep dropping them in the comments. Now let's move on to Chandan Roy's question next. And this is also on YouTube asking, retrieving data, wait a few seconds and try to cut or copy again. And the question is, how do H1B site visits differ from other forms of immigration compliance audits or inspections?
Sure. So there are some site visits, some kind of visits like a DOL visit for I-9, or somebody coming for a public access file inspection. So there are some that are mandatory. You cannot say, no, I don't want to participate. The H1B site visit, on the other hand, that is done by an FDNS officer as a part of ASVVP program. These are
Mhm.
voluntary participation kind of site visits. So the thing is, nobody is coming to arrest somebody. So all they're trying to do is just trying to kind of verify that everything is in compliance, that the employer is complying with the H1B program, the employee is complying with the H1B program. So they are coming to just do a site visit that is typically voluntary in nature, not a mandatory thing. It is voluntary. But again, their goal is they come, they take photographs of the office, they try to talk to some people, get some
Mhm.
information about the job, and they just leave. They are very nice, and most of the time they are very, very professional, and they do their job. They go back, they write a report, send it to USCIS. And when you talk about other immigration compliance audits, the typical audits we talk about are sometimes DOL audits, sometimes audits for I-9, sometimes audits for public access files, etc. So those audits are a little different because sometimes they could be mandatory. For example, if somebody is coming to do an audit for I-9s, a DOL officer coming to do an audit for I-9, for example, uh, people don't have a choice. They have to disclose all the I-9s and they have to participate in that audit, release it to them. And and a public access file inspection, for example, you every company has to have the public access file out for public inspection, and if somebody wants to inspect that, it has to be allowed. You cannot say I refuse to allow my public access files to be inspected. So that is how the
Mhm.
site visits done by the FDNS officers are different. These are more voluntary in nature, and their goal is more to see if somebody is following the compliance with the H1B program. And typically, what that means is, are you working where you're supposed to work from? Are you doing the duties that you're supposed to work on?
Mhm.
Are you getting paid like you're supposed to get paid? That's what a H1B site visit does. And their entire goal is to ensure that this program is not being used to undercut US wages, because if the companies are not paying employees as per the LCA, they are actually impacting the US workforce. So the goal of this site visit is more to ensure, hey, you're paying like you're supposed to, so you're not really driving down the wages, and you're complying with the law and so on. So that's how they're different from other kinds of inspections.
Right, Chand. And I mean, just curious, since we're talking about the rise in site visits, so has it increased lately? I mean, compared to the previous years, and just say this year or like 2023, 24, has it
Yeah.
increased?
Um, so in general, during COVID time, for almost like about 2 years, the site visits were very, very minimal. And then
Okay.
COVID was over. So site visits again have started. And then recently,
Hmm.
what we are seeing is, as you're seeing in the news, a lot of big companies are laying off people. And what that means
Right.
is there are more and more US citizens and people who are authorized to work in US out of a job. So
Hmm.
normally, when this kind of a thing happens, in general, it is also common for USCIS and these government agencies to increase their visits. And the reason is they want to make sure that the companies are following the rules and nobody's getting onto the bench. Because when there are a lot of layoffs, a lot of companies can put people on the bench, and bench is completely illegal as per H1B regulations. People cannot be on the bench, no matter whether you have a project or not. Employee has to be paid. So when there are
Mm.
talks of a lot of layoffs happening, talks of people losing jobs, these site visits help ensure that companies are not putting anybody on the bench. So in general, it is common that when there is a talk of people losing jobs, companies doing layoffs. It's a cycle. So site visits, because the whole goal of site visits is to ensure compliance. And when there is a chance of more and more people getting onto the bench, it is a very important aspect that the government has to ensure that people are not misusing and putting people on the bench and not paying them and so on. And I
Right.
think that is also one of the reasons why we are seeing a little bit more uptick in the number of site visits. And that being
Hmm.
said, people, I mean, when people file a H1B petition, they pay a
Hmm.
$500 anti-fraud fee. And this anti-fraud fee supports this program, provides funding to this program. So in
Okay.
general, uh, this process, this H1B program is designed in such a way that uh, as a part of paying for the H1B petition, this
Mm-hmm.
compliance program is also funded, and it is more like a checks and balances kind of a thing, where the companies that are doing the right thing, the companies that are using H1B program, if they are doing the right thing, they want to make sure that other companies are not using this program to misuse and take advantage of any of the law. And I think that is probably another reason why the site visits went up. And again,
Yes.
it's if any employers are on this show, it is very important that you don't put anybody on the bench, and bench is completely illegal. So just be
Mm-hmm.
cautious, and if you put somebody on the bench, tomorrow you have a site visit, there is a big issue. So things to think and ensure compliance from all sides, from employee side, from employer
Mm-hmm.
side, from everybody's side.
Right. So just to make sure everybody's treated fair and square, I think this is not a bad thing also. And yes, there is a rise in the H1B site visits, friends. Let's move on to the next question, and this is from Paula on YouTube, asking, my fiance has been called for an interview for H1B audit to the USCIS office by the US Immigration Services. They've mentioned that the audit was about the recent amendment on place change. So now the next thing Paula is saying is, he's working remote from past 3 years. Is it normal? Are you aware? Has anyone ever been called for an H1 audit interview or ever even heard of it?
Sure. So normally the USS officers will come to your work location, and if your work location is in a proper commercial office setting, they just walk into the office. And
Mm-hmm.
nowadays, most of the people are working from home. So what USS officer does is typically they will look at the work location. They try to go to the work location, and if it's a home, nowadays what they're doing is they're knocking the door and they're trying to maybe come into the apartment and look at things. Some officers, sometimes what I'm seeing is sometimes either they're not comfortable, or maybe they try to come to the work location, they didn't find the employee. So now what they do is, instead of coming back to the work location again, or instead of trying to re contact the employee, sometimes
Mm-hmm.
they say, hey, can you come to the local USCIS office? And I've seen this happen before, and it is nothing to be concerned about. So what they're saying is, rather than we come to the work location, rather than we come to your house and do the site visit, why don't you come in and we can just have a discussion? So I've definitely seen this happen before, and it is nothing to worry. Uh, but again, what you can expect is, once you go there, they're going to look at your file and they're going to ask you, where are you working? Do you have payroll? What exactly are the duties that you do? And they will compare it with their file and make sure that you are in H1B compliance. And again, when you say remote, to USCIS officer, or to be in compliance, you still have to work from the metro area of your work location as listed on the LCA. So you cannot just relocate to any place you want because it is remote. You still have to be within the confines of the metro area as defined in the LCA. And more than likely, that is what the officer will talk to you about. He's going to talk to your husband about basically the compliance, where exactly is he working from, ensure that he's in compliance. So just because you called for an interview at the office, nothing to be worried about it. I've seen this happen a few times. It is rare, but I've seen some officers where they see a house, they're not comfortable, they just say, why don't you come to our office? So I would not worry much about it, but definitely let your employer know, and just go from there.
Okay. All right, let's move on to the next question then. This one is from Vishnu Vardhan, asking, hello, Chancellor. If I get my petition approval for counselor processing, if by chance I get laid off, can I use the H1B approved petition for another employer?
Sure. And so again, so I think we're talking about the cap cases. So for cap cases, what happens is the start date will be typically be from October 1st. And when you do it as a counselor processing case, what happens is somebody will not even start the H1B in general, because it is counselor processing. You have to actually go for visa stamping to get the H1B activated. And what I see is, if somebody gets a counselor processing approval and somebody does a transfer, in general, the transfer will go through. It should not be a problem. The
Mhm.
problems that I've seen is, if somebody withdraws or revokes the H1B um, before hand. For example, you get an approval, and say before October 1st, your employer revokes your H1B. Then you will not be eligible for transfer. But on the day you do the transfer, if your prior employer has not withdrawn or not revoked the H1B, you should not have any problem doing a transfer. So We have done a lot of transfers for cases where the cases got approved in counselor, but somebody decided to work for another employer because they got a better offer, and we were able to use the prior approval and do either a change of status or maybe another counsel processing approval. But the bottom line is, if your employer revokes or withdraws, or USCIS revokes the H1B for fraud, then you
Mhm.
might see a challenge with the transfer. But if the prior employer, but before the prior employer revokes your H1B, you get a transfer done. I typically don't see any issue with that because you're cap exempt because you've gone through the lottery process and got selected in the cap. You should be cap exempt.
Great. So, Vishnu, there's nothing to worry about. All the best. And if you have any further questions, you can keep dropping them in the comments. All right, friends. Also, I'll just remind you that please don't forget to subscribe to our channel as well. This is Immigration and Jobs Talk Show. And check us out. We are there on YouTube, LinkedIn, Facebook, and also Twitter. You just follow us, subscribe to us, hit the bell icon so that, whenever we have these very important, enlightening, insightful discussions, you can always, be updated and notified and join us immediately. And let's move on to the couple more questions before we end today's webinar, Chand, if that's fine.
Mhm. Sure.
Anusha is asking, I am currently in India on unpaid family emergency leave, FMLA, and I do not have an active client at the moment. My Dropbox appointment was successfully completed on March, and I am aware of the recent changes in the 48-month rule. And if asked about my client during the interview, how should I explain them this?
So I think so. You're on FMLA leave. So what that means is your employment is still active. And when you say your Dropbox appointment was successfully completed in March, and if you got the visa, then you're good. You got the visa, you're good. You just have to let your employer know, and if the employer has a job for you, you're good to travel to US and start working for them. So pretty much you're good. If your Dropbox appointment is done but your visa is not done yet, then probably you have to wait. And then when you go for the interview, you have to make sure you have a valid assignment. You have to make sure you talk to your employer to ensure you have a valid assignment, and then go based off of that. But when because I didn't get it clearly, if your appointment is done successfully, as in the visa being successful, then pretty much you're good. The minute your employer says yes, come in, and you have a valid assignment, you're good to go. And once you get a visa, if you want to stay back in India for a couple of months, it's okay. And there is nothing that says the day you get the visa, the very next day you have to go to US. But the day you come to US, you have to have an assignment, and your intention should be to work for that employer and follow the H1B compliance,
Mhm.
ensure you're working, getting paid. All that stuff needs to happen. So if you got your visa, just talk to your employer, and whenever they say they're ready for you, just come to US and then start working for them. So pretty much it's more about you checking with your employer whether you have an assignment or not, and then coming to US to work. That's pretty much what it boils down to.
Okay. Thank you. Thank you for taking that up for Anusha. Now let's move on to the next one, this last one from Dia asking, what are the potential legal implications and consequences of an employer who has unknowingly hired an H1B worker whose visa was obtained through fraudulent means, such as a fake degree, maybe, or even falsified experience? And how can the employer mitigate any potential damages or penalties?
Sure. I think you used a very big keyword, unknowingly. So that unknowingly will make a lot of difference. So in this whole
Mhm.
criminal law,
Yes.
it is a criminal act if you knowingly do something. So when you say unknowingly, what that means
Mhm.
is you should not have any criminal implications. Okay, so because you have not been a part of that fake document. So if you have unknowingly done something, you definitely will not have any criminal implications, because criminal implications will arise when you knowingly do something that you know is wrong. So that knowingly, unknowingly will make a lot of difference. Okay, so in your case, the first part is unknowingly. So criminal implications, no. And then the next part is the civil implications. Civil as in liability. What kind of a liability will you have? So what
Mhm.
you should do is to mitigate any damages. The minute you know about this document being fake, fire the employee. And if you have
Mhm.
filed any H1B, withdraw the H1B immediately. Okay, because you're taking action. The minute you know that something
Yes.
was wrong, don't get any advantage out of that document, which means you do not get any advantage
Mhm.
out of that guy. Immediately withdraw the
Mhm.
H1, immediately revoke his H1, and terminate his
Mhm.
employment because he submitted a fake document. Okay, so criminal, I'm not worried, but in terms of penalties or potential damages, which is the civil side, mitigate your damages by taking action. So that's how you
Mhm.
prove that you're doing the right thing, which is terminate and withdraw the H1B.
Okay, thank you so much for taking that up, Fatia. Thank you so much, all you folks out there, for your questions. They were really, really very intriguing, and thank you for being so participative, all of you. All right, Chand, I know you also agree. It's very interesting to have all these questions from the audience.
Yes, it was a
Thank you
very
so much,
interactive
Chand,
session,
for
and
yeah.
yeah,
Sorry,
I
please.
was saying the same thing. Thank you all, and it was a very interactive session today.
Absolutely, yes. And that wraps up today's webinar, friends. I hope you had a good time and were enlightened and got different insights into this very topic we discussed today, the rise of H1B site visits. So, yes, a massive thank you to none other than Attorney Chan. Thank you so much for sharing your invaluable time and, of course, your knowledge and insights with us. And I definitely hope to see you again next week. Hopefully, we will discuss another very, very important topic on immigration.
Thank you so much, Nipasa.
Thank you. Have a great day ahead and see you soon.
Yeah, sure. Thank you.
And thank you, friends out there. And, before I really end this show, I wanted to also remind you, yes, that, don't forget to subscribe to us. And a quick reminder about us, that Immigration and Jobs Talk Show. And, we discuss all types of US visas and even discuss everything job related. So don't forget to subscribe to us, like this, and share with your friends, whoever can benefit with this kind of information. So, thank you once again for joining us. And also, these experts, attorneys joining us, they keep providing us with prominent and, providing us with insights. So, definitely. And also, you folks out there, if you're looking for project placement or need any immigration related services, please don't forget to, or do not even hesitate to get in touch with us. The details are on the screen. You can call me on the number 408 or you can even email me at nipa@higherightpeople.com, or even visit our website www.higherightpeople.com. So, yes, thank you so much, all you folks. I had a good time. And if you are watching this after the live stream is over, still do not forget to, keep commenting your questions, because we have our experts who will be more than happy to give out their answers to you. So, once again, this is Immigration and Jobs Talk Show, and I am Nipasa Pradhan signing off for now. Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335 6444 or mail us at nipa@higherightpeople.com or visit our website www.higherightpeople.com.